The United Kingdom, a nation historically shaped by immigration, has embarked on a new chapter in its citizenship policy. Effective from February 10, 2025, a significant change has been implemented, directly impacting those who enter the UK through irregular means. This new rule carries profound implications, particularly for refugees seeking safety and a future within Britain's borders. It has sparked intense debate with legal experts, refugee organisations and politicians questioning its compatibility with the UK's international obligations and its impact on the very fabric of British society. At the heart of this change lies a seemingly simple yet impactful clause. Anyone entering the UK illegally will normally be refused British citizenship. This applies regardless of the time elapsed since their entry, marking a stark departure from the previous 10-year waiting period for those arriving by irregular routes. The government argues that this new rule provides much-needed clarity to the existing system and serves as a deterrent against illegal entry. However, critics argue that the true cost of this clarity is far too high. This shift in policy comes amidst a backdrop of rising anti-immigration sentiment and the increasing popularity of parties like Reform UK, who advocate for stricter immigration controls. The Labour government, under pressure to address these concerns, has implemented this new rule, but not without facing criticism from within its own ranks. Many Labour MPs, alongside refugee organisations and legal experts, argue that the rule is not only morally questionable, but also potentially unlawful. As the UK grapples with the complexities of immigration in an increasingly interconnected world, this new citizenship rule stands as a pivotal moment. Its long-term consequences, both for those seeking refuge on British shores and for the UK's reputation as a champion of human rights, remain to be fully understood. The debate surrounding this rule is far from over and will undoubtedly continue to shape the UK's approach to immigration and citizenship for years to come. The most immediate and profound impact of the UK's new citizenship rule is felt by refugees, those forced to flee their home countries due to persecution, war or violence. For many, reaching the UK involves perilous journeys, often undertaken out of desperation and with limited options for safe and legal routes. The new rule effectively penalises refugees for the very act of seeking asylum, creating a system where their mode of arrival overshadows their need for protection. Central to the new rule is the concept of good character, a requirement for British citizenship. The government argues that entering the UK illegally, regardless of the circumstances, demonstrates a lack of good character, thereby making individuals ineligible for citizenship. This interpretation has sparked outrage amongst refugee organisations and legal experts who argue that it fundamentally misunderstands the plight of refugees. Fleeing persecution, they argue, is not a criminal act but an act of survival, often undertaken with no other choice but irregular routes. The new rule creates a two-tier system, effectively creating a second-class status for refugees who arrive irregularly. While they may be granted refugee status and leave to remain in the UK, the path to full citizenship, with its associated rights and privileges, is now significantly more difficult. This disparity has drawn sharp criticism, with concerns raised about the creation of a system that fosters division and undermines the integration of refugees into British society. The personal stories of those affected highlight the human cost of this policy. Take, for example, the 21-year-old Afghan refugee who arrived in the UK at the age of 14, smuggled in a lorry. Despite being granted refugee status and indefinite leave to remain, he now faces an uphill battle to secure British citizenship due to the circumstances of his arrival. His case, along with countless others, underscores the urgent need to address the legal challenges and moral implications of this new citizenship rule. The ink was barely dry on the new citizenship rule when legal challenges began to emerge, signaling a protracted legal battle over its implementation and compatibility with existing laws. At the heart of these challenges lies the argument that the rule fundamentally contradicts the UK's obligations under international law, particularly the 1951 UN Refugee Convention and the European Convention on Human Rights. These legal challenges, brought forth by human rights organisations and supported by numerous legal experts, represent a significant test for the UK government and its commitment to upholding international law. A key point of contention revolves around Article 31 of the 1951 UN Refugee Convention, which explicitly prohibits penalizing refugees for illegal entry if they present themselves to authorities and demonstrate a well-founded fear of persecution. Critics argue that the new rule directly contravenes this principle by using the method of arrival as a basis for denying citizenship. They argue that this creates a chilling effect, potentially deterring refugees from coming forward and seeking asylum, forcing them further underground and putting their safety at risk. Further challenges are based on the European Convention on Human Rights, particularly Articles 13 and 14, which guarantee the right to an effective remedy and protection from discrimination, respectively. The new rule, critics argue, violates both these rights by denying refugees a fair opportunity to regularize their status, and by discriminating against them based on their mode of arrival. These legal challenges, if successful, could have far-reaching implications, potentially forcing the government to rethink its entire approach to citizenship for those arriving irregularly. The legal battle over the new citizenship rule is far from over. It represents a clash between the government's stated aim of deterring illegal entry and its obligations under international law to provide protection to those fleeing persecution. The outcome of these legal challenges will have significant ramifications, not only for the thousands of refugees seeking to build a future in the UK, but also for the country's reputation as an upholder of human rights on the world stage. The courts are now tasked with the weighty responsibility of interpreting the law and determining whether the government's pursuit of stricter immigration control comes at the expense of its international commitments and fundamental principles of fairness and justice. Beyond the specific challenges posed by the UN Refugee Convention and the European Convention on Human Rights, the new citizenship rule raises broader questions about its compatibility with both international customary law and domestic UK law. The principle of non-refoulement, a cornerstone of international customary law, prohibits states from returning individuals to a country where they would face a real risk of persecution. Critics argue that by creating a system where refugees are effectively penalized for their mode of arrival, the UK risks violating this principle by making it less likely for them to seek asylum and potentially forcing them back to situations of danger. The UK's own domestic legislation also presents potential points of conflict with the new rule. The British Nationality Act 1981, which governs the acquisition of British citizenship, includes a good character requirement. However, the Act does not explicitly define good character, leaving it open to interpretation. Critics argue that the government's interpretation, linking illegal entry to a lack of good character, is overly broad and fails to consider the complexities and nuances of refugee experiences. They argue that this interpretation contradicts the spirit of the Act, which is ultimately designed to provide a fair and just pathway to citizenship. Adding another layer of complexity is the UK's recent departure from the European Union. While the UK is no longer bound by EU law, it remains subject to the European Convention on Human Rights and has incorporated the convention into its domestic law through the Human Rights Act 1998. This means that the government remains obligated to uphold the convention's principles, including the right to a fair trial and the prohibition of discrimination, even in its immigration policies. The legal landscape surrounding the new citizenship rule is intricate and multifaceted, involving a complex interplay of international treaties, domestic legislation, and evolving legal interpretations. As the legal challenges progress through the courts, the UK faces a critical juncture. The decisions made in these cases will not only determine the fate of countless refugees seeking to rebuild their lives, but will also shape the UK's reputation as a nation that upholds the rule of law and its commitments to international human rights standards.